Welcome, everybody. Thank you very much for attending. I know that we're going to have a few people sliding in at the back, so don't mind that. And certainly welcome to everybody who is on Zoom as well. Thank you all for signing up and coming today. Folks on Zoom, you are able to pop in questions in the chat and in the Q&A section on the Zoom function. So feel free to do that as we go along through the session. If anything is answered before we get to the Q&A section, then we'll just ignore your question if that's okay. That is brilliant. So do feel free to write things as you go along. I'm just going to run through what we're going to do this evening. My name is Margot Ravenscroft. I'm the director at Amicus. Big thanks to BCLP as well, which is where we are tonight, hosting the event. We are really honoured and excited to have this amazing panel tonight, speaking about this really interesting and new development in the US, in the death penalty world. I am going to just say a few words about who Amicus is, and then I'm going to introduce the panel. Panel will speak to you about their involvement in this case, and then we will have some time for questions and answers and turn it into a bit of a discussion, hopefully. So that's the plan, basically. So Amicus, we're about 30 odd years old now, and we assist people who are facing the death penalty. We're a legal charity, an NGO. We do not have any government or state funding, so we're a charity and we rely on donations. With that in mind, I should mention that we are this is a free event, but we would encourage anyone to donate a few pounds to Amicus. It would be really helpful for our ongoing work. There is also there's a little poll. So whilst you're watching the Zoom, you can go through the poll questions, and that'll be it's in hard copy in the reception as you go out as well. That will just help us know sort of like how well our events are performing, essentially. So Amicus was started 30 odd years ago, really on the back of a specific case. Jane Officer, who is a retired school teacher, not a lawyer, set up the charity really to support people who are facing the death penalty. We're a due process fair trials organisation. We're not a campaigning organisation, and we really work on the ground in the States alongside some of the fantastic attorneys that we work with, to really give people access to legal representation. And we also work in an academic field, looking at empirical studies to do with constitutionality of the death penalty as well. We have hundreds and hundreds of wonderful caseworkers throughout our affiliate firms who work on these cases, as well as we send out about 30 odd people a year who are postgraduate law students to assist with the legwork that is needed in capital cases as well, across the United States. So that's a bit about Amicus, and lots of our guys are here tonight, so you can nobble them later for information. So we're going to go straight into the panel, really. I'm just going to briefly introduce who we have. We're going to be starting off with Professor John York, who's director of the BCU Centre for Human Rights in Birmingham. He's going to give you an overview of the case, and a little bit of information to grounding as to where we are with this case. Then we're going to go to Dr. Joel Zivot, who is over from Atlanta, Georgia. He's Associate Professor of Anesthesiology and Surgery in the Emory University School of Medicine. He's also a Senior Fellow at the Emory School of Ethics as well, and has written extensively on this subject. He'll introduce himself a bit as well. We were also very privileged to have Maurice Tidball-Blins, who's the UN Special Rapporteur on Executions, as well as Ed Pilkington, who is a journalist, and he's chief US correspondent at the Guardian newspaper and expert in all things journalistic to do with the US, really. And so we'll have that perspective as well. And then we have our UK barrister practitioner, as well as a UK coroner, Barnaby Hone, who is joining us as well on Zoom. And he's going to give us a little bit of a sort of like his take on the case from a UK perspective, and with his background as a coroner as well. So with that in mind, I'm going to pass on straight on to Professor John York. John.
Thank you so much, Margaret. Yeah, and thank you also to BCLP for hosting us. It was wonderful to meet a couple of their colleagues. We had a lovely dinner in the Middle Temple this afternoon, so that was very, very nice. So thank you so much for that. Also want to thank Amicus so much, an incredible charity, and if you do have a spare fiver in your wallet, please donate, because they do incredible work all across the United States, supporting lawyers in helping save the lives of people and making sure that they have effective justice. I'm actually one of, well, Amicus's second intern. In 1996, they funded me to go and work in Oklahoma, and I worked, and I loved it so much that in 1997, I went back to work on federal cases in Oklahoma, and definitely changed my life. And so I owe a lot to Amicus in my in my career in trying to combat against the death penalty. So thank you so much for Amicus. Please donate. I'll give a little overview of the case, as Margot said, and then we'll all speak for about 10 minutes each, snapshot overviews of how we've all contributed to this case and different observations on the case. But really what we're here this evening is to have a dialogue on this important development in the United States, and particularly in the state of Alabama. So it was much more interesting for us to hear from you, and therefore to discuss some of the issues. So we'll definitely have lots of opportunity for that. In Colbert County in 1998, there's a lady called Elizabeth Sennett, and she's at home, and her home is broken into. Her husband is not there. His name is Reverend Charles Sennett, and he is somewhere else. These men cause a horrible circumstance in her home. There is a struggle, there is a robbery, and then one man takes her to another room and then stabs her to death. During this horrific circumstance, there is an investigation for the crime. Reverend Charles Sennett becomes a person of interest. It is found out that he is having an affair, that he's got into incredible debt, and that he's recently taken out a life insurance policy on his wife. He knows then the police are investigating him, and then he commits suicide. The governor then announces that an $11,000 reward will be given to anyone who can come forward and give information upon who committed this awful crime. Crime Stoppers received lots of calls, as I'm sure you imagine. There's one particular call which raises interest for them. Crime Stoppers keeps this person anonymous, and so does the state prosecutors. And information is provided to them that a man called Kenneth Smith has a VCR in his home that's taken from the Sennett's home. Crime Stoppers tell this informant that if you go and get the VCR, it will give police cause to therefore investigate this crime, arrest Kenneth, and then find out who committed this offense. And that's what they do. They keep it anonymous. So this case then comes to trial. A man called Kenneth Smith is the man that we're here to talk about this evening, gets arrested, and another man gets arrested called John Parker. It materializes that John Parker is the man who commits the murder, who committed the stabbing, and that in the trial, Kenneth says he never knew anything about the fact that he was going to commit a murder. He didn't know that he had a knife with him, and all he was told was to go and rough up the wife, to intimidate her. So the case comes to trial. Because of the informant is kept anonymous, it prevents the defense from cross-examining this witness, and also cross-examining other witnesses who came forward to therefore state that Kenneth never knew about the crime, as in of the murder, but that he did have an intention to go and commit a robbery. And so the state controls the narrative at the trial, and then in 1989, they are both sentenced to death. In Kenneth's case, it's found that there is a Batson violation, and those of you who are familiar with the jurisprudence of the United States, so the prosecution has unjustifiably used its peremptory challenges in a way that violates the Sixth Amendment access to justice, and therefore the Batson case, the Batson trial, overturns the judgment. In 1992, that occurs, and in 1996, Kenneth is again sentenced to death. But the jury says to the judge, from 11 votes to 1, that don't give him the death sentence, give him life without parole because of the circumstances which I just outlined, which come to light. The judge disregards the jury's instruction and sentences him to death. Appeals occur throughout the case. In 2010, John Parker is executed. So he's executed in Alabama by lethal injection, and Kenneth Smith remains still on death row. And there are more intricate legal questions with regards to his moral culpability because of the state's withholding of evidence and also denying the defense an opportunity to impeach the witnesses. So therefore, it's a much more complex judicial analysis. So that's why he remains alive. Obviously, we come to a state in which Joel will go into a lot more detail than I, in which the ability of states to impose lethal injection becomes complicated, primarily because of access to sodium thiopental, and then states have to amend their execution protocols, and it just becomes harder and harder. And we see, and there are 3 US constitutional cases: Bays versus Rees, Glossip versus Gross, and Buckley versus Presser, thank you. Yeah. And that develops the jurisprudence restrict the ability to challenge the lethal injection protocol based on 2 aspects within this tripartite analysis. And therefore, we get to a state where states start to say, well, we need to find new methods, and therefore nitrogen gas inhalation becomes one of those methods. And so we find ourselves here today to challenge that. We're here today because we thought that this case does not just involve intricate questions of capital judicial process in the United States, but also it implicates the United States international law obligations as well. Joel and I and a professor in Fordham University called Deborah Deno, we submitted a complaint to the United Nations in a case called Alan Eugene Miller. And in that case, the United Nations Special Rapporteur, we have Maurice with us here today, who'll be talking at the end, communicated with the government to therefore intervene in that case. We saw the value in that in raising transparency on the lethal injection protocol. So we thought that this would be a good case to raise again with the United Nations on this new question of nitrogen gas inhalation. So that's kind of where we are today. The other thing I just want to mention with regards to the way in which the UN has analysed the United States is in a case in 1994 called Eng versus Canada. Now, in this case, very interesting, this is to do with cyanide gas inhalation. And the Human Rights Committee reviewed the United States' use of this and determined that 14 minutes to die via nitrogen gas would constitute a violation of Article 7 of the ICCPR, which is the prohibition of torture and inhuman and degrading punishment. And Joel's going to outline in much more detail the length of time that Kenneth has been subjected to an execution process, but also this implicates our analysis of nitrogen gas inhalation as well for our ability to challenge this method.
Hey, should we go straight on to Joel?
So I want to say that I'm not happy to be here. And it's not that I'm not happy to be talking to you. I take umbrage with the fact that as a physician, I'm involved in this in any way at all. This is not a doctor's job. And not infrequently, I get asked something like, well, if we can't kill them this way, how can we kill him? And I tell people, listen, I'm an expert in unkilling. And if you want an expert in killing, then you should consult a ninja or James Bond. And it's not, and nor should you reverse engineer what I say as some acceptable method to kill people. So for me, the story actually, I think, begins by a theft. And the theft is that the states that performed execution via this thing that we understand is called lethal injection used a drug that I used as an anesthesiologist. And the drug was called sodium thiopental. I did not give the state permission to use this drug. This is a drug that is a controlled substance and is normally administered only, by a physician with a license and so on. But the state, because it controls practice and so on and has its own ability to rewrite these rules, started to use this sodium thiopental. Now, the story that is told is that the last manufacturer of sodium thiopental was a company called Hospira. And they were making sodium thiopental in Italy. And it's a bit unclear as to what was the sequence of events, but somehow the company was approached and asked if their sodium thiopental that they were manufacturing, if they could guarantee that it would not end up being used in the death penalty in the United States. And the reason for the query is because, as Italy is a member of the EU, of course, all EU countries are bound not to make anything that can be used for capital punishment. So Hospira said, we can't promise that, and so we will therefore stop making it. And so suddenly, this drug that I used at the beginning of an anesthetic disappeared from the world market. And I said, well, where did it go? How was it that it, did we forget how to make it? Did we run out of the ingredients? It just was, I didn't understand. And so I started to look into it and see, well, where did it, end up? And I found my way to the death penalty. And I thought, well, that isn't right. So because I am who I am, I decided I would write an opinion piece about it. And I wrote an opinion piece about this. I worked with the Death Penalty Information Center. Again, all these people I did not know. And they helped me. And I published a piece in USA Today where I said that, back off my stuff, states, and if you want to kill people, you're going to have to, use a firing squad or hanging or something else, meaning to be somewhat tongue-in-cheek, I guess. And after that, my phone started ringing. I got calls from attorneys in the US that said, hey, since you've got a big mouth, would you like to do some post-conviction death penalty defense? And I said, well, okay, maybe. What exactly do you need from me? And so it began this sort of relationship, with this, again, this period of post-conviction. And with the question that was asked to me at the time, the kind of defense that was commonly advanced was something referred to as an as-applied challenge. And so the argument is, well, so it required me to go and examine a prisoner and find out if they had any coexisting health conditions. And the as-applied argument would be, well, if you look at the method of execution as applied to this prisoner, the consequence would be a death that would be deemed to be cruel. And so I started to look into this. And I realized that it occurred to me that because of this technique of execution, it was conceivable that there would be cruelty in the death. And so I would take this to court. And I would get this answer, well, how long is it really going to be? And, that's really of no consequence and so on. And I learned that, that a death that is not visibly cruel is not considered to be cruel. It's just as simply as that. And that was so kind of diabolical about lethal injection, is that it solved the problem of the visual. And so the inference was, if something is outwardly not cruel, it must therefore be not inwardly cruel. And that's kind of the way the courts and the public regarded it. And so I kept losing. I lost every time. And it occurred to me that maybe I need to tell a more visual story. And so I'd had a case where there was something that was quite visual. And I told it that it would be, that the experience of witnesses watching this execution will be a lot grimmer than lethal injection. That was one thing. That actually was in Bucklew versus Precythe. So I have the interesting distinction as also having Justice Gorsuch basically dismiss my testimony and disregard what I've said. So I don't like him, and it's personal. And then I know that lawyers, when they argue, it's not personal, but I'm not a lawyer, so it's personal. And then I also had something that was handed to me, which was a series of autopsies of executed individuals. And the question I was asked was about pentobarbital, which was the replacement of sodium thiopental, blood levels, and whether it would be consistent with death. So what I had in my possession actually was a series of full autopsies, 44 of them, I think. And I looked through them and I found something that was surprising and shocking. And what I discovered was, in fact, in most of these autopsies, there was something called pulmonary edema. So the prisoners, pulmonary edema is like maybe this is why I need to give you the trigger warning, because we're going to have some grim conversation. Pulmonary edema is basically like a frothy, bloody fluid that was in the lungs. And so the lungs were what we call as heavy. They were twice the normal weight that they would be. The lungs in an autopsy are removed and weighed, and these lungs were all heavy. And I thought, well, how is that happening? That's not supposed to be happening. I didn't know, and I couldn't really see it in the way executions were happening, although there was some coughing and some other stuff, and I just didn't know what it meant. So I realized that there was something going on here with lethal injection that was not understood. At the time, I worked with, I guess, a journalist from National Public Radio, and through a Freedom of Information request, they got an extra 200 autopsies. So we looked at this almost 250 autopsies of executed inmates and found almost 80% of the time, so almost 8 out of 10 times, there was this frothy, bloody fluid. And so instead of falling off to sleep and dying, you were drowning in your own blood. And that was the story that I thought, okay, well, I'll tell that story, and then the court will thank me for clearing up this question about whether lethal injection is cruel. Turns out that that's not cruel either. So we press on. But what it is, there is this constant kind of eroding of the supply of lethal injection, of the components of it. And then also Alabama had this little cluster of inability to start intravenous's, which kind of set this in motion. And nitrogen gas became yet another method, maybe the 5th or 6th method in the US that that's tried to be used to kill people. Now, nitrogen gas has never been used in this way. It is true that inhalation of nitrogen gas will kill you. We know this because it's an inert gas. It has no kind of metabolic effect in the body. We actually are all of us breathing nitrogen gas now. It's mixed in with oxygen to make air. We can't breathe pure oxygen. That's toxic to us. So we have to mix it with oxygen. I said it's a little bit like, imagine taking a hot bath, and you have to put some cold water in it to make it tolerable. So that's kind of what nitrogen does to air. It makes it tolerable to breathe. But if we breathe pure nitrogen gas, then we will die. We know this because there's been accidental exposure to nitrogen gas in industry. Some people have tried to use nitrogen gas or use nitrogen gas to commit suicide. It's used a little bit in animal euthanasia. So we know it should kill a person. But why again getting involved is in the technical aspect of how the state intends to do this, and will it work in the way that the state imagines it will work. And so at least in my examination of what I can review, and I'll tell you that also that the states through either statute or fiat make a lot of what they do secret. So you get a document that's full of black lines, and they say, here is the document. And so you're trying to kind of figure out what exactly is going on here. Some actually made a comment, maybe there's actually nothing underneath the black lines. It's sort of, nah, actually, there's nothing. So it's a lot of black lines. And so we're trying to figure out what exactly is happening. And at least to my read of it, I'm very concerned that there's issues with the mask, there's issues with the exhalation of the nitrogen gas. And also what's curious about nitrogen gas execution, of course, is that because nitrogen gas is odorless and colorless, and because it will be exhaled into the room, and because it could leak under the mask, you're now talking about not only killing Kenneth Smith, but you could kill other people too. So now you're talking about, imagine again, an execution with a firing squad, as I've said, and now you're lining up, there's your person you're going to shoot, and you're lining up the witnesses next to them. And you're explaining to them, listen, these guys we have, they're not very good shots. Okay, so there's a possibility that you'll be shot too. So here's some forms we need you to sign, that just to acknowledge that there's some risk here of doing this. And so I think that Kenneth Smith must be the worst man in America, because not only is the state willing to kill him, but they're willing to kill other people, to kill him too. And that's kind of where we are. So John and I, got together on this, and we because of these and other concerns, we decided it was time maybe to push this forward and try to make some sense of this and to hold the state of Alabama accountable to what we think are, are grievous violations, both of international law and of I think the aberration, of the use of science and medicine now as an ugly arm of state power, and that's that's my objection. So I'll stop there.
And that brings us nicely on to Morris, actually.
Thank you very much. Can you hear me? Okay. Wonderful. Well,
Yes.
Firstly, sincere thanks to Amicus for inviting me to this remarkable panel. It's a honor, and I must say a pleasure, despite the circumstances, to meet, albeit virtually, such distinguished speakers and activists. So thank you so much. I want to also take the opportunity to thank very especially Professor Jon York and Dr. Joel Zivot, because it's thanks to their submission to my mandate as United Nations Special Rapporteur on extrajudicial summary or arbitrary executions, which they sent to the Office of the High Commissioner of Human Rights in Geneva last November, on the 23rd of November precisely. I was able actually to address this case as required. The submission that they sent is of extraordinary quality, unusually good, I must say, and I want to remark this because it's so important for the special procedures, the human rights mechanisms at the United Nations to have access to such information in order to act as required by the mandates. We usually have to reach out and undertake substantial research to substantiate a submission to a state. But in this case, it was made extremely easy thanks to such a remarkably good submission, both in terms of the case history and the substantiation, both from the legal point of view and the medical point of view. And I wanted to especially congratulate Dr. Joel Zivot for his pioneering work in the detection of pathological signs in post-mortem findings of individuals subjected to the death penalty in the United States. Joel, your work with Mark Edgar is actually groundbreaking, and I have actually referred to this on a number of occasions in my reports. And I do look forward to continue working together and more closely together. because as a physician myself, a forensic doctor myself, in my present position as special rapporteur on extrajudicial executions, when referring to the death penalty, I unequivocally maintain that from a medical point of view, and growing evidence worldwide, the death penalty is tantamount to torture, and therefore the prohibition of the death penalty, in addition to the limitations within international law, including the ICCPR, Article 6, etc., should take this perspective into account. Back in 2012, the then United Nations Special Rapporteur on Torture, Juan Mendes, published a sort of really groundbreaking report to analyze whether the death penalty amounted to a violation of the prohibition of torture. And his conclusion was that it is virtually impossible to impose the death penalty without actually violating such a prohibition. I took Juan Mendes's report and findings and research and developments on this domain since the publication of his report in 2012 to present a statement on this regard on 2022 in my report to the United Nations General Assembly in New York, which included a section on the death penalty, precisely reaffirming the views and the growing recognition that the death penalty amounts to torture and other cruel or inhuman and degrading treatment or punishment. I must say here that that this view is not focused exclusively on execution methods, and I'll come back to that because it's a core element of today's discussion with regards to the method with which the state of Alabama as announced, will execute Mr. Kenneth Eugene Smith. In fact, the death penalty, in my view, and that of many other experts, constitutes a violation of the prohibition of torture and other cruel, inhuman, and degrading treatment or punishment from the moment of the sentence up to the execution itself. And this effect impacts not only the individual sentenced to death and ultimately executed, if that comes to be, but also his or her next of kin. And I'll come back to that. I'll explain this. For example, I have had the privilege of meeting and interviewing members of a remarkable NGO in the United States of America called Witness to Innocence. This is an American NGO of death row exonerees. These are individuals who actually went through and survived the death penalty because at some stage they were found innocent of the charges that they had been sentenced for. And I found the conversations with these individuals extraordinary and stark reminders when discussing some of the elements of what they went through in terms of their experience, their suffering. an extraordinary similarity with the interviews that I have carried out in my capacity as a forensic doctor of survivors of torture in many parts of the world. It is remarkable that for those who survive torture, one of the most harrowing and long-lasting experiences has to do with the threat of death, either of the individual and or of his or her families. And this is what a death sentence is all about. Then comes the death row phenomenon. And this has been recognized, for example, by the European Court on Human Rights back in 1989 in a judgment against the United Kingdom, actually, Suring versus United Kingdom, to be a violation of Article 3 of the European Convention on Human Rights, meaning torture. So the death row phenomena, the anguish of awaiting death, is tantamount to a form of torture. And the committee, the Committee on Human Rights, which is the body which, the conventional body which oversees the International Covenant on Civil and Political Rights, on its advisory opinion number 36, has stated very clearly that with regards to execution methods, there are virtually no execution methods which do not amount to a violation of the prohibition of torture. And with regards to families, again, speaking with members of Witnesses to Innocence, when they explain to me what their relatives and next of kin lived through in the process from their sentencing up to the exoneration, is tantamount to what the families of the disappeared actually suffered in terms of not knowing the fate of what will happen to the loved ones and the expectations and all that. So with regards to this particular case, thanks again to the submission that I have mentioned. My mandate, I have actually communicated with the government of the United States to express the concerns based on international law and the concepts that I have just shared back on the 8th of December. I have still not received an answer, but given the fact that this communication was of an urgent nature, it allowed me also to make a press release, which was issued on the 3rd of January, essentially calling to a halt of this execution. And only yesterday, actually, the UN High Commissioner for Human Rights also issued a statement calling for a stay of execution. And the core of these concerns have to do with the execution method as well, that is supposed to be applied in this case for all the good reasons that Dr. Joel Zivot has already explained. So thank you once again to the friends of Amicus and to the speakers for your remarkable work and for making the work of United Nations special procedures, such as my mandate, possible with the information, with your advocacy, and with your help on behalf of basic human rights. In this case, the stay of execution. And the prohibition of torture. Thank you very much.
Thank you, Morris. And so on that, we will go to what happened next. In a way, we've gone through this kind of slightly chronologically, and go to Ed Pilkington. And what do you do with that press release?
Hi, thanks to Amicus and to everyone else on the panel and for everyone listening in. So I've been in the United States since 2006 as a reporter for The Guardian. In those years, I've developed a sort of mini specialism in the death penalty. At The Guardian, we kind of look for holes in the US media, areas where we think we can contribute something a little bit different. And we identified the death penalty as something that could benefit from a more European sensibility in terms of how you look at it. I mean, it's covered thoroughly in the US, but often I think a little bit pro forma by the US media. You know, it's taken as something that's part of the landscape. It's kind of a normal part of American life. You know, The Guardian, we come to it thinking, no, there's nothing normal about any of this. It's the epitome of abnormal, and that we should report it in that way, which is what I try and do. I'm reporting quite a lot on the Kenny Smith case. I think it's exceptional on a number of levels, but just two stand out. One, the nitrogen method, which we're discussing today, but also the fact that this will be, if he goes to the death chamber next week, it will be his second attempted execution. They tried to execute him in November 2002. Using lethal injection. He was on the gurney for 3 hours. They failed to find a vein and cancelled the procedure. So he's one of two living people in America today, both of them in Alabama, who can describe to you what it is like to be executed. Not to the finish, it has to be said, but you know, for full execution procedure up to the point of actually being killed. As it happened, I spoke to Kenny this morning for an interview I'm doing with him for the weekend. He said to me that on Tuesday he's going to be moved to the death cell. That's a cell very near the death chamber where condemned prisoners are put 3 days before they're executed. Of course, he's been in that cell already. He did it in November 2022. He's dreading going back there. He's finding it difficult to eat. He's particularly worried about the mask that they're proposing to use for nitrogen. Trigger warning, he fears that he may vomit in the mask and that he'll end up dying on his own vomit. That's how he put it to me. And just one other quote from him. You know, he's gone through the trauma of the first execution. Now he's days away from a second execution. It's pretty extraordinary on any level. He said, quote, "They haven't given me a chance to heal. I'm still suffering from last year. And, you know, now we're doing this again, and they haven't even let it be post-traumatic stress disorder. You know, it's ongoing stress disorder." So he's got a very, actually incredibly eloquent, I've spoken to many death row inmates, he's got a particularly eloquent perception of what he's going through. How did we get to this place? As Joel has said, the whole thing about lethal injection is that it is set up as a sort of humane medical procedure, a dignified death. And as so often we've seen, it hasn't been anything like that. And I think similarly in Nitrogen's case, they're trying to do the same thing within a slightly different guise. It actually was developed in 2015 by Oklahoma, who were looking for an alternative to lethal injection. And I'll talk in a minute about why. But what do they do to try and find a new system? They found a former prosecutor, a man with no medical training, who had been the lead prosecutor in the Western Pacific Ocean islands of Palau, which has a population of 17,000 people. They asked him to come up with a new device. He landed on nitrogen, produced a 14-page report in 2015, which was taken up by Oklahoma and then by Alabama. And that's what they're proposing to use next week. Why was Oklahoma looking for a new method? I think it's very significant, this. It was just months after they killed Clayton Lockett in one of the most gruesome executions in living memory. We did a lot of reporting on it at The Guardian. Lockett died in 43 minutes on the gurney from the lethal injections that he was given. Our reporters described how he groaned and writhed on the gurney during that time. He lifted his head off the table and exclaimed while it was happening. It was so awful, and the public response to it was so dire that Oklahoma suspended executions and ended up suspending them for 6 years. And that's when they looked for a new procedure. So I think that's very, very significant that nitrogen was born out of the botched and incapable nature of lethal injections being that medical dignified death that we've so often seen it not being. And now history is repeating itself in Alabama. The reason they're using nitrogen is because they've gone through 3 terrible botched lethal injections in really just the last 18 months or so. Joel mentioned Alan Miller. He's the other living person who can describe what it's like to be executed. They couldn't find a vein for him either, and they called off his execution after several hours. And before him, Joe Nathan James did die, but it took them 3 hours to kill him. Unlike Oklahoma, which has suspended its executions for 6 years, Alabama just took a few months to carry out what most people saw as a pretty cursory review of those appalling botched attempts. And now they're on it again soon afterwards. And who do they choose to try a completely new method on, but no one other than Kenny Smith, who they've already tried to kill and failed. Why I think it's important to think about why is nitrogen in particular being used in this case. Well, I talked about the Oklahoma model that was produced as a response to their efforts to use lethal injection and failing to do that. So I think that's reason number one is the incapability of the modern death penalty states to apply lethal injections in a way that meets the standard of what they claim is a dignified, civilized death. It's so palpably not that they're no longer finding it easy to continue. Secondly, because of the international boycott that has been led by Europe and has gone global since then, of the lethal injection drugs, is proved to be very effective. A number of the states are struggling to get hold of supplies and have been doing increasingly desperate moves as a result of that. And thirdly, a third reason why nitrogen is preferred, the one they don't talk about, and that's because it's very cheap. Nitrogen is all around us. As Joel said, it's 78% of the air we breathe. It can be procured very cheaply and easily, and death penalty states like that idea. Veterinary associations in the US and in Europe have put out guidelines in which they say they do not approve nitrogen for euthanasia of most animals. And I think, and Joel and I have talked about this, it's difficult to make direct comparisons between humans and animals, but I do think it's interesting the reasons that both US and European associations have given for not using nitrogen as a euthanasia technique. They say it can cause distress, and that you should only consider using it if you use a sedative first, so that the animal is unconscious before you give them nitrogen. In the case of the Alabama protocol, there is no sedative to be used before Kenny Smith would be given nitrogen. So I'm just raising that as a point of comparison that I think is illustrative, if not definitive. And lastly, last thing I'd wanted to say is just put this in a bit of context. And this is a tale of two Americas that I'm seeing unfold. In one America, and it's the majority of America, the death penalty is on the way out. It's actually dying on the vine. 29 states have either abolished the death penalty or are pausing executions. And last year, we only saw 5 of them carrying out executions at all. So on one level, this is victory. The movement for abolition of the death penalty is working. On another level, it's failing miserably, because what we're seeing in those states that are still doing it, those 5 states, actually 7 states last year introduced new death sentences, so it's 5 to 7, almost entirely in the South, the sort of former Confederate part of America. In those states that are still doing it, they're more relentless, they're more determined, they're more brutal than they have ever been. And that's why we're seeing two things happening. One, a proliferation of attempts to look to new techniques such as nitrogen. Other states looking to the firing squad. Some are bringing back the electric chair. And secondly, a plethora of moves to impose secrecy on the procedure. That many of the death penalty states are trying to shroud what they do in total secrecy so that none of us know what they're up to, so that when brutal, terrible botched procedures happen, we don't get to see them, and so that the media can't report them. And we see it as our job at The Guardian to make sure they fail in that mission. And last thought, on a point of context, another reason to be worried about the way death penalty is going, even whilst it seems to be dying out, and that is we're seeing Joe Biden turn to it in a way I find very distressing. They secured federal death penalty for the mass shooter in Pittsburgh. They just announced they're going for the capital case for the mass shooter at the supermarket in Buffalo. Now, don't get me wrong, these were two of the most egregious, appalling crimes in our lifetimes, absolutely unconscionable. But in a way, that makes it worse from my perspective, because for someone like Joe Biden to go for capital cases in these appalling events, it's to imply that there is something about the death penalty that is worthy, that there is such a thing as such an appalling crime that it makes it okay to try and kill someone. And I think that's another reason to have pause and to redouble the effort in terms of, opposing the death penalty in all its forms.
Wonderful. Thank you, Ed. That's brilliant. So we're going to finish off now with Barnaby to just really get a perspective, sort of like from the UK and from his position as a coroner in the UK.
So I'm very grateful to be on such a esteemed panel and have enjoyed the talk so much. So I didn't know how to approach it. Do I approach it as a barrister, former intern, or a coroner? So I decided to approach it briefly from each of those. As a barrister, it's very interesting that this case fundamentally revolved around, on the evidential stage, two issues which go across the whole common law world: anonymous evidence and conspiracy. The fact that we have those issues there, two areas of evidence which are fundamentally unsafe because the anonymous evidence couldn't be challenged, or the issue of conspiracy, how far can a conspiracy touch different people, is very interesting. But what really struck me is actually that this issue comes from, for me, when I had a lot of hope. Because when I was an intern back in 2007, I was told, and it's very clear, that the death penalty challenges come down into four areas. First, evidential, proving that somebody was guilty. Second, sentence, and how much discretion should be used in the sentence. Third, the actual penalty itself, death, and also the time it takes and the process it takes. And the fourth set of challenges is money and how much it costs. Now, ultimately, that might be how the death penalty stops. But when I was an intern, I had a great pleasure of doing it in North Carolina. And we went to a couple of death penalty conferences. We met a young Kentucky death penalty team, who were the team who I believe worked in the Bays case. They told us about this challenge. And the challenge that went on in the series of cases, I was very quiet at the back, trying not to sort of spill my tea on anybody. But it gave us hope. It gave us hope that this was a challenge, along with the work again in Europe, particularly to stop death penalty drugs being moved over, that this would stop the death penalty. Because it was clear at that time, and it's got even worse, that the series of botched executions were cruelly inhumane. Now, I'll get to whether I think it's any death penalty is cruelly inhumane, but there was that level of hope that Bays would lead to a stop in executions along with the other work, and the lethal injection, which had long been seen as the most humane, and in inverted commas, form of executions, would be stopped. It hasn't worked, as the different panelists have shown, it has led to a slowing down of drugs, changing of protocols, and the more extreme of the states getting more extreme. And that, for me, brings great sadness, but there is still the hope that as different execution methods are ruled out, as they are highlighted and only can be highlighted in as much sunlight as possible, the idea that, as Ed said, we've got states being more secretive scares me. Why would you be secretive if you are proud of your procedure? If you're clear about your procedure, why? Because they want to stop legal challenges. And that worries me, but that does also hope, and I might just be an over-optimist, as I often am, that it does mean that we are pushing those states. We're showing that this is something which is inhumane. If they had a humane way of killing somebody, they could do it openly. But it is clear from all the executions going back as long as I can remember that that is not the case, and has got worse as Oklahoma's 3 series of botched executions, the botched executions in Alabama, including for this gentleman, have highlighted. And I remember back to the series of botched executions in Florida as well. So is there any more hope? Well, the nitrogen execution, what particularly strikes me is the fact that they're not using a protocol which is clear. They're not using a protocol which is tested. They're not using a protocol where we know how and who is safe. As highlighted in earlier talks, nitrogen is a silent killer. Nitrogen might well affect people around the person who is being attempted to execute it. If an execution method is safe, surely there'll be an open and clear procedure which had been tested and which had been proven before it was used to be humane. The fact that it is not something which an American in one of these states or we would use to put down our beloved pet surely should speak volumes. As a coroner, I've seen death, and sorry, that shouldn't have sounded as melodramatic, but the idea that there can be a humane death, I once thought that I could understand arguments of certain execution methods being humane. I now doubt it greatly for 2 major reasons. A, death is very, very rarely humane from whatever I've seen, and people facing death find, of course, go through imaginable pain. The point raised earlier is also very true. Holding somebody waiting, facing death amounts to torture. Seeing people in cases I've done where they've been facing threats of execution has caused severe difficulty to them, PTSD and others. So could you have a process? Now, some would point to Japan where it's very quick and sudden, but then is it fair? And also, does that actually take into account the process of death? My view is not, having looked at it all. My view is, of course, not the final arbitrator, but that if you're going to do it, there must be a clear method, and this is not it. That a method must be tested, that a method must be looked at in the round by the scientific community. And we must be blunt about what process is going to happen. The idea of the vomit being mentioned in the mask is one of the number of issues that I thought could arise, having seen people suffocating, and seen cases where people consume carbon dioxide rather than nitrogen. Now, the process from what I've read is slightly different, but still it is somebody suffocating on a different gas. That doesn't sound particularly untraumatic to me. Now, that might be exceedingly British understatement, but without actually ever testing it and without going through different procedures, relying on a lawyer who's been a prosecutor and who's written a report seems to me to be wholly inadequate. And hopefully, and I say hopefully because I always remain hope that the process can be challenged, that series of challenges will pursue this and will continue to outlaw and stop series of executions while keeping the spotlight on the death penalty in America and other areas, and show what actually happens and show the barbarousness. Because if that continues to be highlighted, then in my view, eventually, and it might not be as I thought after Bayes in 2-4 years, but it will continue to put that pressure on, educate people, and see what actually happens. Because the real threat here is both this method of execution, but also the practices that people are trying to avoid scrutiny. That's my 2 penny worth, for whatever it's worth. But again, I'm very glad to share the panel with such more esteemed colleagues and listen and see how the matters progress. Thank you all.
Thank you very much, and thank you to all of the panel. We're now going to go to our discussion section. So people in the audience, in the live audience, do pop your hand up, and one of our roving mics will come and find you.
Could I make actually
please.
a comment, if I might, just before?
Yeah.
I think I'm on here.
Okay.
There's 2 things that I wanted to address. One is this word humane. I think humane is important because, and I know John and I have discussed about the problem of language and the meaning of words, which is something, of course, that that lawyers are very alive to. So this word humane has no meaning to me. I think it means human-like. We mean it, of course, here to imply some kind of a kindness or nicety. Of course, the expression "I was only human," we say it when we've done something terrible and not something good. And the law doesn't actually care a whit about an execution being humane. It just has to be not cruel. That's what the law requires. And I wrote something years ago about that. I've said that the absence of cruelty is not the presence of humaneness. It has no meaning here. The second thing I wanted to mention is this concept of the word experiment. So what's been talked about is this idea that this is some sort of ghastly experiment. Now, experiment is a term of art, and it has a particular kind of meaning. In the scientific world, experiment is of a kind of investigation that follows a certain set of rules and of reasoning. An experiment is something also, if we want to extend that for a moment, let's consider how we would design an experiment here. So this is a human experiment. It means that the subject is a human being. And we know, for example, that human experimentation must follow certain sorts of rules. You can't just conduct an experiment on a person without satisfying the requirements of human experimentation that has been established after Nuremberg. And one of the, there is a problem of using prisoners as subjects because of questions about agency and volunteerism. But there is a provision, for example, that a prisoner could be part of an experiment. In that circumstance, the experimental methodology has to show that it would benefit the prisoner in some way. Seems unlikely that if Kenneth Smith was involved in an experiment here, that it would show him any benefit. So it's clear that there can be no experiment here, no ethical way of doing this. And again, it's not the, when we think of experiment, I guess we think about maybe a mad scientist. And so again, we're trying to kind of use the word pejoratively, but again, to take on the word, the meaning of it, it's important to know that this isn't, calling an experiment, gives it a tiny bit of credibility where it deserves none. So that's just wanted to make that point.
So that's actually just to come back on that, Joel. One of the questions we've had on the Zoom was from a defense attorney who has said that that is one of the arguments that they've tried in state court to say that any new protocol that comes in is tantamount to an experiment or testing, perhaps, on their clients. That's not really got any traction. And they were wondering if there is, what would be the more persuasive argument, or is there a more persuasive way of putting that?
Well, I mean, what's so damn frustrating for me
To
if
the
I-
legislature, yes.
Yeah, if I may, is again that people keep trying to use science and medicine to sanitize what cannot be sanitized. So even when you say protocol, okay, you're suggesting some kind of thoughtful, method of some sequence, that has, again, some meaning. It's really just trying stuff, okay? And I think that, what's interesting about Alabama and execution states that try to do execution is that although they've stolen, from the look and feel of medical practice, they've not stolen the right parts. And what part they have not stolen is medicine's commitment to figuring out when it makes mistakes and how to correct its mistakes. Other organizations understand about mistakes. Classically, for example, the airline industry uses the National Transportation Safety Board to evaluate its mistakes. It's a matter of public record, and that's why flying on a plane is safe. So Alabama has no interest in learning from its mistakes. It does the same thing every time, and as we know what the definition of insanity is, there it is. So in terms of like how to make an argument that's persuasive in court, I don't know. I mean, maybe this is a John question for me. I know that you can't make medicine, like medicine is not helpful here. It's not a function of trying to just reconfigure or use terminology or asking for an experiment to test this. And as I said before, it's not my problem to solve. It's the state's problem to solve. They've kind of pushed it onto the prisoner that they have to prove that the state's method is harmful, and there's this kind of a priori assumption that it's not. And this is, troubling, very troubling.
John, do you want to come in and comment on that?
I just have a very short observation. Under international law, as Maurice will well know, every aspect of the analysis of the death penalty is focused on the function of the state. What makes this, to use, I'm trying to think of a better word, but it's evil, is that the jurisprudence in Bayes, Glossip and Bucklew turns that on the head and places it on the inmate. Yeah, so and a feasible alternative method. And so if you can find a feasible alternative method, then you go to that one. But as Justice Sotomayor has said, what about if they're both torturous? So it's evil. It's a judicial function it's perverse to change the burden of proof, where international law says it's the role of the state to justifiably punish people under the Article 6 and 7 and 10 of the ICCPR, but the US system has changed it. So yeah, I have sympathy with the lawyer. It's what argument can you create?
And just Maurice, I wondered if you wanted to comment on that. Oh, you just muted at the moment, sorry. Classic Zoom.
Yeah, sorry about that. No, I thanks for giving me the floor to comment on that, but I have nothing to add. I think John's remarks are right on the spot. Couldn't be better articulated. I concur 100% on what he just said. Absolutely.
Ed, I know that you have reported heavily on this issue. Yeah.
Well, just a quick add. I mean, that is exactly what's panning out with Kenneth Smith. He didn't want to get killed by lethal injection, so he raised objections through his lawyers to that. The Supreme Court required him to come up with his own alternative, which, as John says, is perverse, asking a death row inmate to be a sort of expert in execution techniques. He came up with nitrogen because it was out there because of Oklahoma having done it, put it on its statute books, and now the federal court that last week gave the green light to the use of nitrogen. They throw that back at his face and say, "Well, you chose it." And so what the Supreme Court has done in requiring death row inmates to come up with their own choice for an alternative is to put the lawyers in these cases in an impossible position, because they see their job as saving the life of their client. So they argue forcefully against lethal injection and all the terrible things it does to people that we've been talking about. But they're then required to give an alternative method. When they do that, the state then turns to that alternative method and forces them to argue against the alternative method, at which point the appeals court say you can't do that because you chose it. So it's like a complete catch-22, which lawyers are falling into. There's no way out of it as far as I can see. And of course, you know, the person who suffers most at the end of the day is the prisoner, who then goes to the death chamber.
Thank you. Okay, I think we had some questions in the room. Thank you.
Thank you for a very, very interesting and exhaustive explanation of the in and outs of this case. And my question is about the sort of obvious question is about evidence, and the evidence in law and the evidence medically, which I think there's a massive disconnect as far as I see. And, you know, just not an expert in any way, and there seems to be a huge hypocrisy around the visible, not visible. And your study on the medical side, which was it 444?
The autopsy study was 250 approximately autopsies of, you know, prisoners executed by 2 methods of lethal injection in the United States.
So a reasonable sample.
I think it's a reasonable sample.
Right. And so it's not. So when you say pulmonary edema, that's what, you know, people at top of Everest die of. And that means you're drowning, as you say, on your fluids.
Yeah, I've treated, you know, many patients with pulmonary edema, and no one likes it.
No
So,
one likes it. Yes,
no.
one likes it. And so when a court says that this is not a visible, and it's an internal medical phenomenon, which is quite well understood, what exactly does that, how is that lawful in terms of what you were talking about, burdens of proof? And I'll leave it at that.
Well, do you want to go first?
So if you're gonna approach this by law, there's first of all 2 ways. There's the normative way of the 3 cases which I outlined. So you've got Bayes, Glossip and Buccleuch. So that focused primarily on the way in which we analyze execution methods. But there's another way in which the judiciary is given guidelines to engage with science, and that's under a case called Dalbert. And this is to do with the analysis of the federal rules of evidence, the way in which judges are presented scientific testimony and how they have to balance competing perspectives and then give a judicial interpretation of that perspective. Now, from your particular question on the judicial consideration of pulmonary edema, they have not given that a full judicial analysis. The way in which it has been presented is that it's just pushed under the carpet. It's there, it's been presented to the court, but has it been presented with an in-depth overview like we have with lethal injection? The answer is no, and so I think we need to present it in a much more authoritative way, using the data like what Joel has investigated.
So the burden of proof on this would be what? What standard?
So it's the number 1. So it's under the 3 cases. It's A. You have to demonstrate that the execution method is what's called super adding pain. So you have to, first of all, be an assessor of what pain is. If it does, then you go on to the second level of standards of you have to demonstrate, okay, a feasible alternative method to this super adding of pain. And so under the jurisprudence of this, begun with Chief Justice Roberts in Bayes, emphasized by Justice Alito in Glossip, and then the ribbon on the top of this wonderful present by Justice Kavanaugh and Justice Thomas and Justice Gorsuch. Although I do have to say, Justice Breyer really likes Joel, and he said a lot of nice things about him in his dissent of Joel's testimony. But really what it is, it's putting this in, and it's impossible. And Justice Roberts in Bayes affirmed the United States Supreme Court has never held a method of execution in violation of the Eighth Amendment. And so not only are they saying we're going to give you this impossible standard, but they're also stating that we have not found a method that's been violation of the Constitution. So it really is, it's awful. I don't know, this jurisprudence is perverse. It's like returning to the pre-Furman versus Georgia how states treated defendants before Furman, and now it's just a US constitutional affirmation by the Supreme Court of this. And it's unheard. I mean, I can't think of another jurisdiction that might be, because I know there's some other capital punishment experts here in the audience, but a way in which there has been this complex turning turning it upside down of this rule of evidence and the burden of proof. International law does not allow it, and therefore it's just perverse. It's evil.
So after the UN complaint became public, or the press release, a member of the state legislature in Alabama referred to, not me by name, but was the so-called expert. So now I didn't pick that title myself. Okay, so I'm an expert according to the court because I was, hired, because I passed, a Daubert test. The Daubert test, which I think replaced Fry, is problematic because it actually is a little bit of it creates a kind of judicial discretion that not all of the elements of Daubert have to be satisfied. So a judge can just pick a few. So it still kind of weirdly empowers the judge to decide who is an expert and who is not. So I've been in a very weird situation where I am now on one side, and on the other side is someone that I think, frankly, is not an expert, okay? Like, is someone who does not have the credentials, I think, to make what they say, but because the judge has decided you're an expert and you're an expert, here I'm in this weird competition with someone who just does not have the background that I have. Again, I didn't, take any training that in my, that would make me an expert in this problem. So it's based upon, the experience that I have in other ways. So that whole question about that is how it ends up being this weird battle of the experts. And if the other side says garbage, then it sounds like maybe to some ear, I'm saying garbage too. So we're all just saying garbage according to the court, and this is kind of, it gets into this strange spiral of this kind of thing. So, whether there's nothing that prevents a justice from just saying, I think Zivot's just full of it, and I don't believe him, and so it's frustrating to try to represent this, to make these things clear. With respect to the evidence for nitrogen gas, what do we know? Well, we know something about mice. Okay, so, to quote Steinbeck, I guess, of Mice and Men, men are not mice. And so to make statements about nitrogen gas based upon mice is problematic, but certainly we know that nitrogen gas, when mice get it, it's not exactly a positive experience, as much as we can glean the mental state of a mouse. There was some research in the mid-60s that looked at nitrogen gas in healthy volunteers because they were actually doing a study at the time about low oxygen exposure. And they used nitrogen gas. And in this small cohort of healthy volunteers, most of them at around 15 to 20 seconds of breathing pure nitrogen had a seizure. And so when you have a seizure, few things happen. First of all, you stop breathing. And when you're not breathing, of course, you're not breathing the nitrogen. And so it's maybe going to delay your nitrogen uptake, and maybe that will prolong your execution. So now you're seizing. And when you seize, of course, it's a very kind of hypermetabolic state. There's this problem, that I think that Kenneth Smith is concerned about aspiration. So one of the great pleasures of being put to death is that you get to have this last meal. There's a whole lot of stuff about the last meal. Not every state does that anymore. I think Alabama still does. And there's a lot of talk about the last meal. So let's say that Kenneth Smith's last meal is fried chicken. And so now he has his fried chicken, and now it's sitting in his stomach being, metabolized and decomposed by his stomach acids. And now he's on the table, strapped down, lying flat on his back. He has nitrogen gas. He has a seizure. The lower esophageal sphincter, which keeps the contents of the stomach in the stomach, relaxes. The contents of the stomach passively, ascends in his esophagus, and his vomit ends up in his mouth, of course, now held there by the mask. And so when the seizure stops, perhaps, and he begins to breathe, if he does, he's now at risk of, aspirating the contents of his partly metabolized, acidified fried chicken, and that will go in his lungs. And so now, if you're wondering how that's going to look, I don't think it's going to look very good. And it's not going to feel very good either.
Well, that actually answers one of the questions that there was on the panel. One of our other attorneys were asking about more details on the issues with nitrogen inhalation. So thank you for that. And on that, we have another question off the Zoom. Again, this is turning into a workshopping arguments for the lawyers, actually. Any thoughts on what could be persuasive to a very conservative legislation considering enacting legislation to provide nitrogen to persuade them against it? So this is I think we're talking about Louisiana, following on from that. Following on from Alabama and other states that are looking at it. So there are other states now looking at this particular method other than Oklahoma and Nebraska. And so the attorneys are looking at trying to get ahead of that legislation. So from any of our panel, as we're building up this.
I think that this is a conservative issue, okay? Believe it or not. Okay, and I'll tell you, this publicly, that when people ask me about my opinion about the death penalty, my position is that I'm agnostic. As a physician, again, I'm here for my stuff. And if a state decides that the death penalty is lawful, I guess that's up to the state and so on. But in terms of just being a conservative issue, I would say, where's an originalist when you need one? Like read the Constitution. It's clearly and unambiguously in the plain language says what it should be, and it isn't. So it feels to me to be quite a conservative issue. And why the conservative electorate or conservative government has not globbed onto that is because I guess they're not reading the Constitution very clearly.
So maybe more constitutional arguments to the legislature might be the answer. Anyone else? I know, John, you probably have a thought on that or not?
I kind of just pick up on a holistic observation that Ed made about the two Americas. And that is a conversation in which you're trying to create an illusory world in which the death penalty can be humane. So to have that conversation, it is the conversation in thinking that it's possible. But I think the other America needs to win. And we need to start to say, you're asking the wrong question. You just be stopped. Just stop. Stop this line of legislative provision. Stop this political language. Stop this legal language. We need to therefore look at the other states that are abolishing. You just can't create a humane method of execution. Joel, interestingly, mentioned originalism. And one of the big problems is that in the US jurisprudence, especially in the Supreme Court, they think that originalism is the presence of the death penalty in the Fifth Amendment. And in the Fifth Amendment possibility of a capital trial, that ipso facto preserves the death penalty in the Eighth Amendment. But in fact, when you read the annals of Congress, it's the other way around. Because Samuel Livermore, he said when he reviewed the Eighth Amendment, when there is an alternative means in which we can invent in the future, that would be an appropriate method to adopt. And so what he was saying, that if we cut off people's ears, we maim their faces, and we hang them, if an alternative means in the future can be adopted, it will be prudent in the legislature to do so. Now, if that's true, if what he's saying is true, that means the death penalty is not preserved in the Eighth Amendment. And what it means is, therefore, the Fifth is subject to the Eighth, not the Eighth subject to the Fifth. So originalism and conversations with the legislatures is that we therefore turn it upside down, and we can take away the Fifth by taking away the death penalty from the Eighth. And if we can say your conversation about trying to create a humane method in the language of the Eighth Amendment, therefore is a non-starter, we therefore then take it away from the Fifth Amendment. But that's getting a bit complicated. But just on this, I just want to thank Morris publicly for engaging with our submission and the US government. And just to let everybody know, yes, it was a 60-page review of this topic, and it'll be published on Friday on the Centre website. I will tweet the link, and I'm sure Amicus will retweet. So if you're following Amicus on Friday, we'll be publishing it. And I just want to thank Morris and thank the United Nations, because keeping this message alive, not just in America, but letting America know that the world is watching as well, it will really agitate some people, but it gives hope to a lot of other people as well. And so the continuation of that is very important. So thank you so much, Morris, for what you've done.
Absolutely.
I want to just say also another conservative, if I could, another conservative idea. Okay, so one of the things that I think also in the language of this is that you look at the character of these guys on the row, mostly it's men, and there's some of them, become, they undergo this kind of characterological conversion. They all kind of change, like you're not killing the guy that did the killing, okay? So I've been to death row in 8 states. I say I've never met Lex Luthor in prison. And I think that this kind of looking for the good guy on the row is problematic for people who want to be tough on crime, So then you say that we've got to find these good guys. And I think that that's not helpful, because the prisoners don't have to pass any character test, and so you don't have to worry about first painting them as positive people, as people that everyone likes. And I think that, again, that people who, when you talk about humane, like what I hear people say is they get all upset because they say, well, this person is a killer, and they showed no humaneness when they killed someone, and so they're owed none. And it kind of circles into that. And I would say, I really don't care who they are, what they've done. Like, yes, of course it matters, but in terms of their defense, and as a physician, I have the same strategy. I say, and you just have to understand what I mean when I say this, that the kind of patient I like the most is the one I like the least as a person, because then I feel like the work is pure, You don't have to pass any character test for me to take care of you. You can be terrible, you can be, great. I don't care who you are. I take care of you. You have a right to my care because here you are. It's the same thing with these guys on death row. We don't have to cherry pick the ones that everyone likes. Take the worst one if you want, the absolute worst one you can imagine. And even that person is owed, all the protections that the law provides.
Thank you. Ed, yes.
Yeah, just a couple of thoughts. I mean, John's point about just stop, I find that personally incredibly persuasive, and that's how I see the world. I think it's not going to play in America, unfortunately, at the moment, for a couple of important reasons, and that is, it's that two Americas thing. As the death penalty dies, it shrinks to these fewer and fewer states, and in a way, those states are then allowed to do more and more what they want without the rest of America caring about it. One of the most alarming things I find personally when I'm reporting about the death penalty is the feeling that in America, not even sort of progressive Guardian reading Americans really care that much about the death penalty. And that may be just my own impression, but I think there's a grain of truth in it. And I think it's because it's happening down in Mississippi, it's happening in Alabama or in Missouri or Oklahoma. It's not happening in New York or Chicago or LA, where most of Guardian reading types live. So that's one reason. Secondly, the Supreme Court, we've talked about what the Supreme Court has done, this catch-22 of flipping the evidential burden onto prisoners. But even more importantly, they're just not taking cert petitions anymore. They're not taking appeals at all. And they're not giving any reason for it. And this is the 6-3 new Conservative supermajority. The main impact they're having is just simply turning their back on death penalty cases. And, Kenneth Smith is a classic case that one would imagine will end up in the Supreme Court. And, only 2 or 3 years ago, you would have thought there's bound to be one reason or other that the Supreme Court puts a stay on it, because it could be the untested nature of the nitrogen. It could be the fact that Smith was already been through a full execution procedure and survived it, which is, if that's not cruel and unusual punishment, I don't know what is under the 8th Amendment. And yet I fear, and I kind of gruesomely predict, that the Supreme Court just won't take his case at all without any explanation, which is becoming the norm now. So what this means is that kind of lack of interest on the part of the Supreme Court is being passed down the line, and I think is already, you can see it, but is also going to the future, is going to sort of facilitate increasing a freedom of behavior on behalf of the increasingly relentless death penalty states. Just one other quick thought. I think, therefore, maybe the only hope, and following Joel's thought about conservative ideas, I think cost is the overwhelming one. Although you have a few death penalty states still at it, even they are introducing fewer death sentences, and it's because the counties that control the prosecutions, they just can't afford the death penalty anymore. It's incredibly expensive. It takes 30 years to kill someone. Each year costs, I don't know what the figure is, but it's enormous. And you can see nitrogen going the same way. You could already see the seeds of that. They're going to have to get hold of pure nitrogen from producers. There's already green shoots of evidence that some producers of nitrogen don't want to sell to death penalty states. They'll then take measures to stop their products reaching the states, just as we heard about Hospira earlier, and sodium thiopental. Producers of drugs have stopped their products reaching death penalty states. So you can just see the whole wheel just starting up again, and the whole thing happening all over again. It's not going to be pretty, but in the long term, it may just mean that counties in very red states and very death penalty states just can't afford to do it anymore.
Thank you. Yeah, indeed. Do we have any more in the room? We've got a few more online. So I'll go to the one online. Really, it's another kind of thought on if Kenny Smith is executed without visual problems, what are the panelists' thoughts on whether or other states will move to nitrogen, and how quickly that would happen? Would a botched execution from nitrogen, meaning one that causes suffering, be something that you could glean from an autopsy? Like, could it be shown in a physical way, I guess? And is there any effort to have systematic autopsies in these executions?
I was involved in a series of executions in Arkansas. So Arkansas discovered, to their horror, that their execution stockpile of medications, again repurposed as poisons, were heading their expiration date. And so they decided that they were going to try to execute 7 people in 2 weeks, because that's how long they had. So I was hired as an expert. I talked to all of those 7 guys, and I think that Arkansas ended up killing 5 of them. And what would happen would be after the execution, the judge would kind of get people on the phone. There would be people who had witnessed the execution and would ask them, what they thought about what they saw. And the people who were for execution said it looked great. And the people who were against execution said it looked horrible. So the question is to what will people say what they see? It will entirely depend upon what they think that they're seeing and what they want to see. Like the problem, of course, is that the law turns on what the prisoner experiences, but there's no way to gauge it. So it becomes this story about witnessing. And the problem of witnessing is that executions are highly curated events. I witnessed an execution. I witnessed the execution of Marcus Wellens in Georgia. And I remember thinking not much happened. Actually, what actually happened in that execution was that as the execution began, there was a corrections officer standing next to him, and the corrections officer collapsed and fell onto the body of Marcus Wellens. And by the way, while I'm in there watching, I'm behind glass as a witness. They take away your phone, they take away your watch, they take away there's nothing you could do. You have to kind of do this sort of magical recording of what you're trying to see. And so when the execution begins, when I think it's beginning, I start to count in seconds because I'm trying to kind of get some timeline as to how long this is going to take. And once the corrections officer, of course, falls, then, and now I think I've lost count. Okay, so the room fills with people. They drag this guy out and they replace him with another, corrections officer. And at some point, they say, okay, Marcus Wellens has died. And so I'm left with thinking, what did I just see? It's hard to know what I saw. I did have a chance to review Marcus Wellens' autopsy later. He, of course, also had pulmonary edema. He did, twitch a bit and started to move. But then, of course, once someone fell on him, it was harder to get what was going on. So what this execution will look like and what we're allowed to see is unclear. What are they going to show us? Like I was involved, with Joe Nathan James, who was the other, kind of quote, botched execution of Alabama. So there was this story about Joe Nathan James being, there was this long delay before he was brought before people. And the comment was, well, Joe wanted to say something. He really wanted to make a statement. And by the time he was before people, he was quite muted and he seemed docile. And people were wondering, well, what happened to him? Did they medicate him? So by law, each state has different rules, but Alabama does an autopsy on executed people. It's done by the state. The autopsy results are kept secret for a long time. So when I heard this, I said, let's get a second autopsy. So I organized a second autopsy with the family, got the body of Joe Nathan James, and did a second autopsy on him. And what I found was that, his arms, he had on his arms many puncture sites, but also evidence of something that's called a cut down. So it's an old thing that we used to do where you take a knife into the skin and you open up the skin to try to expose a vein that you can't otherwise see or feel to find a place to stick your needle. So he had a couple of cut downs to some, and you could see because there was blood at the edges of these incisions that it happened when he was still alive. Now, I doubt, of course, that they gave him any anesthetic when they were doing that, and whether it was ultimately successful. So, so here I said, oh, well, I took pictures of it. Here are these cut downs. This is part of what the state is doing. The state, of course, is not allowed. There was nothing in the protocol that allowed for a cut down. And when it was brought forward in evidence, the state said, we deny doing that, but we will never do it again. So, so what we're going to see here, is not at all clear to me. How will they get him into this position? How will he be secured on this table? Like I know that, for example, the straps go up and down the body and the arms, but at least with lethal injection, you're kind of covered with a sheet to make it look a little bit better. You don't see all these thick leather straps that's strapping the body down. And when prisoners are brought into the execution chamber, they're brought in by they're shackled and they're brought in by 6 big corrections officers who hold every part of them to make sure that they don't struggle when they're placed on the gurney. So what you get to see and what you don't get to see, is important. So whether or not it's going to be visual enough, I don't know. I don't know.
I know that we are slightly over time now, so we'll end with the last question on the panel to the whole panel. It's really thoughts on the Eighth Amendment, that punishment shouldn't be cruel or unusual. We've talked a lot about the cruelty aspect, the unusual aspect, given that this is this hasn't been used before, and perhaps we were talking earlier about the linguistics on this, so I'll pass on to John maybe to kick off on that and then get everybody's comments before we close.
Okay, so 9 days ago, the district court gave judgment to allow Alabama to proceed, and the 11th Circuit, as we speak, is currently considering oral argument on this. The district court judge has changed the language from unusual to novel, and so it's not. This is a novel approach, and so what we see is that the control of language within the court is now minimizing our ability to challenge what the Constitution actually says. So yeah, so I come back to my original point. It's about control of language. That's what we've got to challenge.
And maybe final words from Morris and.
Oh, thank you. Just to recap, I just want to thank Amicus once again for the remarkable work. Amicus was born back in 1992 from its work on the case of Andrew Lee Jones, very much founded on the memory of Andrew Lee Jones. I hope that the remarkable work that you have carried out on behalf of Eugene Smith, actually, well, I have two hopes. One is that thanks to all this work, he will be spared the execution next week. And second, that as Amicus was born from a gruesome landmark case, that Mr. Smith's gruesome case will help launch a similar campaign by Amicus, I think, about the equation of the death penalty with torture. I think there's growing material, there's growing thinking to that effect, and I am convinced, as in my capacity as special rapporteur, but also as a physician and someone opposing the death penalty, that this, both from a strategic and a tactical point of view, in the US and in other countries, retentionist countries, is a way forward to further reduce the use and application of the death penalty. So thank you so much for all your work, for organizing this panel, and for inviting me today. Thank you.
Thank you so much. Thank you, Morris. Thank you so much. Ed, final comments?
Yeah, I'd like to thank Amicus too, but I'd also like to thank the lawyers involved in capital cases. I mean, whenever I do a story, I work with the lawyers. I always find them the most incredible people. I have absolute admiration for you who are doing that work. And I feel your pain, because I can stand back and be very European and say, is this cruel and unusual? The whole thing is cruel and unusual from the beginning to the end. But you guys have to work with as John says, the language that's in front of you. You don't have the privilege of stepping outside that language. You have to work within it. And so all power to your elbow. I think the job you do is incredible and very, very difficult, because you're having to work from within, and that must be a very painful place to be.
Thank you, Ed, and thank you for all of your work that you do as well. Barnaby.
I also would like to thank Amicus and the insights shown by the panel. I've really enjoyed it. I think one of the most worrying things is the way the Supreme Court are treating these cases and how that trickles down, because it goes into what Ed was talking about in Insight. But that is a theme which doesn't seem to have any clear answers to at this moment. Thank you.
Thank you, Barnaby. Thank you. And Joel, last comments from you.
I mean, I want to thank Amicus like everyone else, and I want to very much also again thank the United Nations. Really, this feels to me like when you do these cases, you just feel like you just lose, you know, and you make the best argument and then you lose. And I have been impressed at the United Nations, interest in this. And it's been, I think it's had a very important impact, that the scope that the UN, the special rapporteurs, and just the organization, I think, has really done something that I think is new, novel, to borrow from Judge Huffaker, and in a positive way. That I think that if this is and Ed too. I think that the media, the United Nations, because unfortunately the courts are failing to, it seems, to do what we think that they should do. And so now, unfortunately, or whatever, the reality is that we need, media attention on this, the United Nations calling this, and these, I think, are hopeful, and positive findings, and I'm really just grateful for that.
And I just want to round off by saying thank you to all of the panelists. I echo Joel's sentiments with the United Nations getting involved in this, and the journalists that have done some amazing work on reporting this in a really sensitive and thorough manner, as well as John for all of his work, of course, on this, and bringing this panel to us as well. Again, big thank you to BCLP for hosting us. And I know, just following up on some of the words that Ed mentioned, we've got quite a few wonderful capital attorneys on the Zoom today, so really appreciate you guys attending. I don't think we may not have quite solved the correct argument to present in court at the moment, but hopefully it's got some people thinking about it, and we can work on how to best present these issues in court and going forward. And finally, thank you very much to all of the audience for turning out today. And I'm sorry we've ran over, but massive thanks to everybody. So just brilliant. Thank you again. Thank you.